Dumelang! Welcome to my channel, Botswana Thinking Law, where I bring you and the law closer. This is part 2 and a continuation of our discussion in relation to the law and employment. Before we get started in this video, I'd like to put in a disclaimer. This is not legal advice. This is simply a sharing of general information. If you have a problem of a legal nature, please engage the services of an attorney. Now back to our video. The issue I want us to discuss, and this is a very contentious issue from time to time, is the issue of rest periods. And this includes work hours, how many hours a person can work or should work in a day, how many hours a person can and should work in a week and a month, and so on. The first issue is that when a person works as an employee, in every 7 days that they work, and this is consecutive days, so if you work every day, then within that 7 days you should have at least one rest day of 24 hours. So the work day might be 8 hours, but the rest day is considered to be 24 hours. And typically this rest day is Sundays, because in terms of the law under the Employment Act, Sundays are a rest day. This therefore means that in every 7-day cycle, an employee actually works 6 days. If an employee is, however, a shift worker, then the period of rest within the 7 consecutive days of work is different. In respect of shift workers, when they work, their rest day might not be a Sunday. It can be any day of the week, provided it's within this 7 consecutive days. And they are not given 24 hours, they are given 30 hours as a rest day. Therefore, it differs on whether a person is a shift worker or not. If an employee is required to work on a rest day, then they have to be paid double their basic daily pay for working on a rest day, or they can be given an additional day where they can go on rest. And this additional day has to be taken by this employee within 10 days of having worked on a rest day. So this means if an employee is required to work on a Sunday, which is the rest day recognized by the Employment Act, then the rate of pay for that employee for that one day will be double their daily rate for their salary. And this is a basic pay. We're not talking about benefits. But instead of that, they can also be given an additional rest day. So if an employee has a 6-day work week and they have Sunday as a rest day, they are required to work on a Sunday, they will be given another rest day in substitution. And they can take this rest day within 10 days. If they work on a Sunday, then a week can pass. And then before 10 days from that Sunday where they worked, they should have taken the additional rest day they were given instead of being paid for. An employee on any particular day should not work for more than a period of 5 hours without being given at least a 30-minute break. If an employee works from 7:30, for example, then by 12:30, they should be given at least a break of about 30 minutes. When an employee works on any given day, they should not work for longer than 8 hours a day or for longer than 48 hours a week. However, there are instances where certain type of jobs might require an employee to work for longer than this allocated period. And to cater for this is where now the law deals with issues of overtime, which we will discuss later on in this video. If, however, an employee's work week is 5 days, so if an employee works from Monday to Friday, then their hours of work on a daily basis are 9 hours. And this 9 hours includes the rest period. And this rest period, unlike the one where an employee works 8 hours, cannot be less than 1 hour. That 1 hour might be taken as a whole, or it can be broken up throughout the day, as long as at the end of this 9-hour work period, the person has had a break of about 1 hour. And I know when people calculate their hours of work, they don't include the lunch hour. When we talk about this 9 or 8 hours, we include the lunch hour because you're still at work even though you are on break. Where an employee is required to work outside of these allocated hours, then as previously stated, they're entitled to overtime pay. And overtime pay is calculated differently depending on how many days a week this employee works. However, in terms of the law, an employee should not work overtime of more than 14 hours a week. This overtime, when an employee works 5 days a week, will be calculated at 22 days for every month. Where an employee works 5.5 days, and that means Monday to Friday, it's a full day, and then on Saturday is a half day, then their overtime will be calculated at 24 days in a month. And if the employee works 6 days a week, their overtime will be calculated at 26 days a month. And for clarity, when I say calculated at these number of days per month, I mean that in order to calculate how much overtime an employee is entitled to, you take their basic salary, look at how many days they work a week. So let's use the 5 work day example. Then the overtime will be calculated at 22 days a month. So the salary will be looked at. Let's say this employee earns 22,000 pula a month. This 22,000 pula will be divided by 22 days, meaning that the employee every day earns 1,000 pula. Then you break down that 1,000 pula into the hours in order to calculate how much they're entitled to for the overtime that they've worked. Employees are not supposed to be allowed to work for more than 12 hours in a day. So if we're talking overtime, and let's say this is an employee who works 5 days a week, meaning that their work day is 9 hours, then the overtime can only be for an additional 3 hours because they cannot work for longer than 12 hours on any given day. However, some of these rest periods are different in relation to shift workers who might be required to work for longer than 5 hours at any given time, depending on the type of work, who might be required to work longer than 8 or 9 hours on any particular day, or longer than 48 hours in a week, provided that at the end of the month, when calculations are made, they come to this shift worker having worked in 48 hours a week. And what I mean by this is, if in week 1 the person works 50 hours, let's say, in week 2 they work another 50 hours, and in week 3 they work another 50 hours. They've worked for more than the allowed hours per week by 2 hours every week. So that is 6 hours in total that they've worked for longer. The 4th week, they should be allowed to work only for 42 hours, because if you add the 6 hours to the 42, it makes 48. So in the entire month, all the hours worked in a week are combined, and then they are divided by the number of weeks, which would be 4 in a month, then those number of hours worked in the week should not be more than 48 hours on average. The next issue to discuss when it comes to rest periods is annual leave. And annual leave is one of those issues that people are constantly asking about. To say, how much time do we get as annual leave every year? And for clarity, annual leave we're talking about where an employee is allowed to take a rest from work and where the employee continues to be paid even when they're taking a break from work. The rate of annual leave earned is 1.25 per month worked. So annual leave is earned. So if you work 1 month, then you earn 1.25 annual leave every month worked. At the beginning of the year, let's say you're starting your new job in January. You don't earn your annual leave until the end of January. At the end of January, you earn 1.25 days. At the end of February, you earn another 1.25 days, making it 2.5 days. And in total, within a 12-month cycle, a person would have earned 15 days of paid annual leave per year. But a person has to use up at least 8 of those 15 days on any given year. Any annual leave that is not taken is then transferred to the next year. So if an employee uses the 8 days within the first year of employment, then it means the other 7 days go to the next year. And then in the next year, they only take 8 days. It means they're left with carryover of 14 days. In the third year, they have to use up the entire 15 days that they would have earned in that third year. And on top of that, they have to also use up the 14 days that they have been carrying from the other 2 years. So in the final year, the employee must take a total of 29 working days of annual leave. Otherwise, if the employee does not take those days, then the employee loses them. The employer allows the employee to go on leave because leave is granted at the convenience of the employer. An example is when the company is working on a project that needs everyone to be at work or a specific employee to be working. Then the employer can refuse for that employee to go on leave during that period. However, an employer should not make it impossible for an employee to go on leave. So if there is no requirement for that employee to be there, like an urgent project that requires that specific employee, then the employer should be willing to allow that employee to go on leave. And remember, these are work days. They don't include weekends or rest days, and they do not include public holidays. So if your rest days are Saturday and Sunday as per your contract of employment, remember, in terms of the Employment Act, a rest day is automatically a Sunday, but sometimes an employer and employee can agree to have 2 rest days, being a Saturday and a Sunday. Then the annual leave does not include any rest days, either provided for in the employment contract or in the Employment Act. Where an employee at the end of their employment, and this could be where an employment is terminated by the employer or by the employee, then any leave days that are not used up by the employee, the employer would have to pay the employee for, provided that these leave days or annual leave days have not been forfeited. And this goes to what I was explaining about the 3 years. The next issue I want us to discuss is the issue of paid public holidays. Paid public holidays have been misunderstood by people for quite some time. Not every public holiday is a paid public holiday. If you go to the Employment Act, there are only 8 paid public holidays, and these days are New Year's Day, Good Friday, Easter Monday, 1st of May, President's Day, the day following President's Day, Independence Day, and Christmas. Those are the only paid public holidays in terms of the Employment Act. You must bear in mind, however, that there are other public holidays that are declared in the Public Holidays Act. However, these other public holidays are not paid public holidays. The only paid public holidays are these 8 that are mentioned in the Employment Act, and outside of that, any public holiday that is taken is not a paid public holiday. What that means is, if there's a public holiday that is declared, then the employee will not come to work, and the employer is entitled to deduct that 1 or 2 days from the employee's salary. I know it's a bit confusing because you're thinking, but it's a public holiday. How am I working on a public holiday? But that is the law in relation to employment. The next issue, and please, you can leave a comment down below if you want me to clarify this point in relation to paid or unpaid public holidays, because it causes a lot of confusion for a lot of people. Because even employers will continue to pay employees even for an unpaid public holiday, because having to then constantly calculate, okay, do I deduct this 1 day here or do I deduct this 1 day there, is tedious. So employers then decide, you know what, I'm just going to pay this employee unless they take more than is allowed in relation to annual leave. But for unpaid public holidays, employers are just like, okay, I'm just going to pay them. Right? And the perfect example for these public holidays is the Boxing Day, which is a public holiday, but it's not paid. It is the day after independence, is not a paid public holiday. If a paid public holiday falls on a rest day, that is a Saturday or a Sunday, Saturday for those employees that work 5 days a week, or Sunday for those that work on 6 days a week, then the next working day will be considered to be a public holiday. Where an employee is required to work on a public holiday, just like in relation to rest days, then that employee will be paid double for that work, which is double the basic daily pay, and the calculation is similar to that, which is 22 days for a 5-day working employee, 24 for 5.5 days, and 26 days for a 6-day week working employee. Or they can be given a day instead of payment, and that day has to be taken within 10 working days of having worked on a public holiday. So it's similar to where an employee is required to work on a rest day. And in addition to that, it also differs in relation to shift workers. The next issue on rest periods I want to deal with is the issue of sick leave. And this is paid sick leave. An employee has 20 days, working days, of paid sick leave every year. So at the start of January, when you go to work, you are automatically given those 20 days. You don't have to earn them like with annual leave, right? So they start with you at the beginning of the year. During the course of that year, if you take 1 day of sick leave, then you don't have to bring any certificate to your employer to show that you were sick. So you can simply communicate to your employer or a representative of your employer to say, hey, today I'm not feeling well, I won't be able to make it to work. 1. However, if your sick leave is for longer than 1 day, then you have to bring a medical certificate And this medical certificate should account for the entire sick leave period. So if you're sick on day 1 and you believe, you know what, this might go into something longer, you go to your doctor or to the hospital to get sick leave, which will start on that specific day. If you say you are sick today and then tomorrow you continue to be sick, if you go to the doctor the following day, then your sick leave will start on that day, which means this one day that is unaccounted for will be deducted from the annual leave. If an employee completely finishes this paid sick leave day, and when I say paid sick leave day, I mean that when an employee is out of work because they're not feeling well, and this does not cause a deduction from their salary, and that is a paid sick leave day. If an employee completely finishes their sick leave day, let's say this employee started in January and in May they are horribly sick and they completely use up their 20 working days of paid sick leave, then the deduction will then go to the annual leave. And once the paid annual leave is finished, then they will go into unpaid leave. And this is where an employee goes on leave and the employer deducts every day that they're on leave from their salary. Unpaid leave can be for as long as the employer is willing to stay without having the services of that particular employee. However, if it is for a continuous period, and then an employer might decide to let the employee go on the grounds that they are not medically fit to continue in their position at work. The next issue when it comes to rest periods is in relation to the employment of women, which is called employment of females in the Employment Act, but that's besides the point. And it focuses mainly on the issue of maternity leave. A woman who falls pregnant has to notify their employer by certificate from a medical practitioner or a midwife and so on within 6 weeks of them giving birth. And then this employee has to go on leave for that 6 weeks before they give birth. The employer also has to give another 6 weeks after the child has been born to this particular employee. This is cumulatively a period of 3 months. And during this period, the employee is not paid a salary, but they are given what is called a maternity allowance. The maternity allowance will be 50% of the basic salary, and they will also be entitled to any other benefits they would have been entitled to had they not gone into confinement. So the employee must tell the employer within 21 days of giving birth that they've given birth. This maternity allowance is paid in 3 installments. The first one is paid during the first 6 weeks before the lady goes and gives birth. The second one will be paid within the 6 weeks of them giving birth. And then the third one is paid in instances where the lady or the woman who has gone to give birth requires an additional period in order to deal with pregnancy or birth-related illnesses. This then gives her an additional 2 weeks, meaning they have a total of 8 weeks. So the third payment would be during the additional 2 weeks if they don't come back due to birth-related illnesses. When a woman is pregnant, she cannot work while she is on this maternity leave. And when I talk about this, I'm talking about the 6 weeks before she goes to give birth and the 6 or 8 weeks after. If she goes and works somewhere else, then she forfeits her maternity allowance. On top of that, a woman who is pregnant cannot be fired, or the employment cannot be terminated within 3 months of them giving birth. So if, for example, this employee is due to give birth in April, at the end of January, this employee cannot be fired. If this employee is fired and it is found out that she is pregnant, remember the notification for pregnancy is only given within 6 weeks of birth, but you can't fire her within 3 months of birth. And that is before the birth is given. If the employer fires the employee in that 3-month period, then the employer will still be required to pay this employee the maternity allowance. This is the 6 weeks before they go and give birth, which is confinement, and the 6 or 8 weeks after they've given birth. So technically, you're required to continue to pay this lady even if they're no longer an employee. And this is done in order to stop employers who want to fire women because they are pregnant, in order to run away from not paying them during maternity leave. If a woman goes back to work after giving birth and having the necessary maternity leave, then they will be given 2 30-minute breaks every day to go and feed the child. This is over and above the usual rest period that this employee will have. So if the employee is an employee who works 6 days a week, remember they're entitled to not less than 30 minutes as a rest period. In addition to that 30 minutes, they're entitled to 1 hour every day. And this 1 hour a day can be taken as 30 minutes twice a day, or it can be taken as a full hour in that day, depending on whether or not the parties agree. So if you add these 30 minutes, it means this employee can have a rest period for themselves for 30 minutes and then an additional hour to go and feed the child, making a total of 1 hour 30 minutes. If this employee has a rest period of 1 hour because they work a 5-day week cycle, then they're entitled to a cumulative 2 hours, 1 hour rest period and 1 hour to go and feed the baby. The parties can agree on how this can be taken. Can be taken as during lunchtime, or can the mother or the woman decide, you know what, I'm going to leave 1 hour early from work. One thing I want to add in relation to maternity leave, and I had put up this discussion on my Twitter and my Facebook page, is why does the law not provide for paternity leave, which is leave by fathers who are expecting children or whose children have just been born? Because if we are on this push for bringing equality between the genders, then one fundamental aspect is to encourage and foster a close relationship between fathers and their children. And this fostering of the relationship starts at the very beginning. Of course, at the moment, paternity leave is left to employers, and the employer, wanting to get the maximum benefit out of an employee, might not be inclined to grant men paternity leave. And that's the reason why the law should step in. And the law can make the necessary measures or put measures in place in order to ensure that paternity leave is taken in a manner that will not be prejudicial to the employer as well. Thank you for joining me. Please like, share, subscribe, ring the notification bell so that every time I put up a video, you get notified. Follow me on my Facebook page at Botswana Thinking Law. Follow me on my Twitter at BW Thinking Law. If you want me to discuss anything at all that you feel that I might not have covered in part 1 or 2, then please leave a comment down below, or leave comments on my Facebook page or on my Twitter. I always appreciate hearing from you and your questions and having engagement from your side. Thank you for joining me. I'll see you in part 3. Bye.